Make sure. All right, we're back in the House Judiciary Committee on Thursday, February 22nd, and I'm trying to find my bill number.
694.
It's 694, and we're hearing from Rebecca Turner from the Defender General's office on H694. Thank you very much for being here and being flexible and being able to come this late in the day.
Thank you, Rebecca Turner from the Defender General's office. For the record, and in the enviable position of keeping you guys here after the floor.
It's not 4:30, so yeah.
Some of us have a life.
With that said, I know that there have been witness testimony on this bill already. I'm not sure you've heard what I'm about to share. And so to the extent that I urge you, even if this is the late hour, just to I put up right up front sort of caution and concern about taking these amendments and sort of thinking of them as closing a loophole and should be done quickly. In fact, I've heard and understand that there's already an intent to consider considering the definition of sexual act and sexual conduct throughout Title 13. I understand there's some interest in considering whether changes should be made across that title and to be doing that next session. If that's the case, if it's already a plan, I would urge you to take a step back and stop pushing forward an amendment on that front, because that would capture the concerns that would be brought up next session, right? So it makes sense to do that. But here, let me share with you what I think the effect of changing this is. And I know you've heard testimony about this. It broadens the acts captured. Right? I understand that there was discussion of not just choosing one or the other, sexual act versus sexual conduct, but now an or. I don't know if that's been subsequently rejected, but even if you do the or, you're now maximizing. So both types. So you're not missing out. So the effect is, of course, to broaden the type of conduct that would be covered under this crime. A crime that fundamentally captures consensual sex. I just want to make sure that's clear, right? This is not just capturing non-consensual sex. This is capturing adult or minors who otherwise would have the legal authority to consent to sex, 16 and up, right? It would criminalize that. So this is criminalizing more consensual sex under these two parameters. It's incarcerated, right? The individual is incarcerated in the corrections officer, or in the case of the second part, it is sort of a sweeping category of a relationship between the child or a minor and the other person being 48 months older at least. A minor is defined as under 18. So we're talking about capturing the 16, 17-year-olds and the 19-year-olds, right? The assistant coaches. It's not just limited to the school front. It's anyone who has position of power, authority, or supervision over the person while undertaking the responsibility professionally or voluntarily to provide for the health or welfare of the minor. Or providing guidance, leadership, instruction, or organized recreational activities for the minor. Think about how sweeping that is. So we're talking about potentially this bill capturing more consensual sex acts, because that's what you're doing, right? Between 15, 16, 17-year-olds and 19-year-olds. So people who they may have gone to high school with, right? But now they've aged up. Does this capture, for instance, lifeguards? Oh, no. Is that someone who's in a position of supervision? Right? And it's a recreational activity. I think that.
That's your question.
Yeah, go ahead, Ken.
If you have an assistant coach that's 17 and they have
Sexual conduct?
sexual consent
Yeah.
with each other, because that 17-year-old is an assistant coach, he or she would be in trouble.
subject to a crime, punishable up to 5 years. I think
Wait, where is it? Where is if you tell me where the,
If under 3258,
Yeah,
it
let's
has to
get-
be 48 months older than the minor.
so. If the scenario is a 15-year-old
4
and a
years.
17-year-old, a 17-year-old, a minor is anyone under 18. So a 17-year-old and a 19-year-old, 15-year-old.
We
So
got
I
the-
get that, but what,
15-year-old and a 17-year-old, sure. Who's to say
Weren't you
that,
just saying a 17-year-old assistant
17
coach?
17-year-old assistant coach
right?
and a 16-year-old.
Right, so, that's not the 48 months, I missed that. So that's a 12 months difference, but it's a
It
two-year.
has to be a 48-month difference, and then if the person is under the age of consent under sexual assault statute and the age gap doesn't apply under the sexual assault statute, then it's gonna qualify as sexual assault anyway.
Under 16. That's under 16.
I'm saying 16,
You can legally have sex without it constituting a sexual assault.
16 and 17-year-old is not illegal.
but but he or she is an assistant
It
coach.
is not illegal under.
It's not
32.
48.
Oh, because you're only talking a 1 year age difference. Say it was an 18-year-old instead of a 17-year-old, right? Then you would have fallen into this
I
category.
get
No,
that, but
if it's an 18-year-old and a 16-year-old,
It's still 2 years.
it's still.
It's still 2 years.
But it's 48. It's
It's
48
it's
months.
at least 48. It's not more than 48. So it's at least 2 years difference.
But what if it is more than 48?
Then you also, is at least
48
48
is-
or older.
48 is 4 years.
but the assistant,
Yeah.
Thank you. Oh, my goodness. I'm having this moment. Thank you, Michelle.
So
For
it would-
4
it would
years.
have to be
It's a 4-year
a
difference. Let's be clear, not 2 years.
16-year-old And a 20-year-old,
but
with the
it-
20-year-old in a position of power over 16-year-old.
so
And that's
this,
current law.
so the 17-year-old assistant coach
Oh my gosh, it's late in the day.
could be considered under a person of power.
But
That's,
they are not going to qualify because there's not the age gap.
You have both.
you have to have both.
Yes.
Okay,
They
so,
have to be
okay.
at least 4 years older
And
and in a position of power supervision over the minor. And then if you're talking about a 17-year-old and you've got and you've got a big age difference, then it's going to fall under our regular sexual assault statute anyway, because it's not going to fit the age gap.
I got that.
So 17-year-old, 23-year-old, 23-year-old assistant coach, 17-year-old minor would fall into this. So 4-year difference. So the question is this is now, it is currently law. Where the effect is to now add more sexual conduct acts, the activity, right? That is still ultimately capturing consensual sex potentially, right? It's not just capturing non-consensual sex. And of course, that will then cross over into other criminal offenses already on the books. So my point is simply to think about what that is. Now, it's not just we should be concerned. The US Supreme Court has issued not many, but a critical decision on this, the right to privacy, the right for people, adults, and in this case, Vermont allows for 16 and older to have consent, right? This is about the punishing and deciding to criminalize because of this specific relationship, which is broadly defined, right? Of who can fall within these relationships. But the US Supreme Court has recognized that there is a substantive due process privacy right to have intimate relations, right? With adults. And I think that this is Lawrence v. Texas, 2003. And there they were reviewing Texas's anti-sodomy crimes, and they struck that down under substantive due process. There was also equal protection concerns. And there, even though this is not the same in terms of sodomy, right? The language that the US Supreme Court does is helpful in terms of navigating and saying that whenever the state legislatures start engaging in creating crimes where there is no injury, right? Then you're on thin ice. right, on this front. Now here, there's a presumed injury because of the age, except that in other instances, sex is allowed, consensual sex for 16 and up, right? So the question is this enough? So I think that is something to be cautious about, to not rush into, that if you're going to be considering a wholesale review of these statutes, to consider it at that time. Is there a problem? Is there people who are not being able to be charged and prosecuted right now? There doesn't seem to be, I haven't heard testimony that this is a problem in the current statute. So I would just consider before just jumping in and expanding. Now, while there's been discussion about how these different phrases expand the sexual activities, we're talking about expanding sexual activities that no longer require any contact. Don't even require touching. Okay, so consensual sexual activity not involving touching or contact. That's how expansive the other definition of sexual conduct is. And so I just want to put that out there in terms of if there's no problem that is having to be addressed, why this expansion, again, further expanding criminalization, otherwise consensual sex. Now, the same concerns apply in the other statute that you are considering adding and changing this to, and that is the section 3257. That's sexual exploitation of a person under the supervision of VOC. I heard testimony again, you need this for consistency's sake. I would say that consistency for consistency's sake is not a reason to again expand criminalization of potentially capturing, again, consensual sex, right? And so that is, I heard that it would bring consistency to the definitions in PREA, the Prison Rape Elimination Act. I happened to pull up the definition of sexual or rape, right, in PREA, and it is not, it's actually much more narrow. There has to be at least contact and touching. They don't go as far as these definitions where you don't have touching. So I just want to clarify the record here.
Where do I find that definition? I'm trying to find.
Yeah, PREA definition is in Title 34, USC section, this is a long number, 30309, that's a definition section. There's a definition of carnal knowledge, which requires contact. There's a definition of rape, which is section 9. And all of those require some kind of contact. Again.
Yeah, go ahead.
We heard last session when we were taking testimony on the sexual, I can't remember now if it was acts or conduct between law enforcement officers and people under investigation.
Yeah.
And I thought we heard pretty compelling testimony that there actually cannot be consent because of the nature of that relationship.
Mhm.
What would you say about that in the case of a DOC inmate and a DOC officer?
You know, I understand that. I also think that consent among adults, even though it may be even harder, isn't impossible to have, right? And that certainly captures this. I also think that, well, it's not something that ODG or that Defender General's office would support. The question is whether you criminalize this conduct, right? Isn't this something that DOC can otherwise take care of with the firing and practices, right? Why does the state need to criminalize this? If it was coercive or violent or non-consensual, it's already separately a crime, right? So we're talking about a situation where there's considerable overlap with this language with current sexual offenses on the book. So I'm not trying to give that a pass. That's absolutely not what I'm doing here. It's about making sure you understand what this statute is also covering, and it's criminalizing potentially consensual sex. Now, in the prison context, I think it's PREA is critical. The goals of PREA are critical. We absolutely support that. Prison eliminate, rape in prisons, the elimination of it absolutely should be the goal. Is this a valid policy approach to that? Now, one of the alternatives that legislatures and studies have shown, you think about the prison context, you think about intimacy and touch just general. Forget about the crime of rape. But there in Vermont, we are not one of the other jurisdictions, there are 4, that allow conjugal visits, for instance, right? Our visitation parameters in Vermont, I've looked into, is pretty limited. If you get on the list that permits contact visitation, you're allowed perhaps a hug, maybe 2, one at the beginning, one at the end, not too long. No kissing, right? That's it. If you are not deemed to be passing DOC's discretion in terms of determining you get contact visits, then you're on the no contact list. No contact visitations are glass in between, right? We have had attorneys I've talked with who've had to, because of space issues, use the no contact rooms to have attorney conversations. And they've had to just end them because they end up shouting to each other through this glass because they cannot communicate and hear each other. It's shouting, not because there are other people around, but because the glass is so thick. Right? And she had to end the no contact visitation because she couldn't hear her client and make the call in the parking lot. Now, when you think about this, it seems like apples and oranges, right? But what studies are finding is that when correctional facilities permit some level of intimacy, touch, right? Basic fundamental human needs, that has a direct correlation of lowering rape, prison rape. And so it's something to think about because California, Washington, Connecticut, and I think Oregon are the 4 that allow 3 at least for conjugal visits. And it is something that if this committee is interested in really locking down and improving upon dropping the numbers of prison rape, to think beyond criminalization, right? Think beyond the statute. And that is one area. Anyways, I know the day is long. That is what I have for this.
So I guess I'm not seeing how just the definition under PREA is really that far off from what we're doing. There's maybe a couple things that are not included.
I think the most significant is the PREA definition of rapes requires contact with another person, right? Touching certain places.
That's mostly what sexual conduct has to involve. It has to be intrusion, intentional touching. I guess bestiality and masturbation don't require that, but
yeah, masturbation doesn't require it. I mean, and so that isn't included. So to the extent that it was represented that we should have consistency because it brings it in line. I actually think that the present definition it covers it, or certainly it doesn't add and include these others.
right. Okay. Other questions for Rebecca? Thank you again for coming over. I appreciate it. And we have your compatriot probably coming back tomorrow afternoon to talk to us a little bit about sealing. So.
All right. Okay. So thank you. Have a good night.
All right. Thank you.
Thank
Sure.
you.
See ya. And we will adjourn until tomorrow. If it's a short floor, which I think it is.
It is.
We will do some voting tomorrow morning. We got the trust bills. We've got timber trespass. Actually, timber trespass, I should see if Michael Grady is available.
Going to be
In the morning.
probably at least 15 questions on the parentage bill form.
Especially with the amendment.
So we'll adjourn.